From the Wisconsin Taxpayers Alliance, Wednesday, September 28th, 2011. A brief interview with Todd Berry, President. 3, 2, 1. Mr. Berry, you recently conducted a review of how states elect Supreme Court justices. What did you learn?
Well, we learned this discussion is as old as the country, if not older. We've always been fighting over it. And if people are interested in seeing our findings, they can go to WISTAX.org. Suffice it to say that the issue is again on the front burner in Wisconsin. We thought it was important to give people some background.
How do other states select their Supreme Court justices?
In short, in a lot of ways. About 12 states appoint them, either by governor or legislature. About 22 states have elections. Some are partisan, some are nonpartisan, like Wisconsin. And 16 have what is called merit selection.
In Wisconsin, some people are advocating for a merit-based approach to selecting state Supreme Court justices. What is that, and how does it work?
Well, it started in Missouri in 1940, and the basic idea is there's some kind of nominating commission that selects names, forwards them to the governor, from which he or she must appoint to the Supreme Court. Once the justice is on the court, then later the justice has to stand in a retention election, which is sort of different because they run unopposed and you vote yes or no, in effect.
What are the benefits and problems with merit-based selection?
Well, the benefits are that it gives the appearance of generating higher quality candidates to name to the Supreme Court. The problems are that it often ends up being just as partisan as a regular appointive process, because the nominating group can be partisan. But probably the biggest problem is relatively new, and that is that all campaigns in the U.S. have become so expensive and so nasty that retention elections and merit situations have become as testy as other elections.
Will merit-based appointments make campaigns cleaner?
Well, that depends. If there's a justice that's fairly uncontroversial, if you will, they're likely to be retained with little notice or discussion. If the justice is somewhat controversial, then we'll see an election very much like the Supreme Court elections we've seen in Wisconsin in recent years, only ours are nonpartisan elections, but retention elections can be just as expensive and just as hard fought.
Why are these elections so contentious?
Supreme Courts at the state level are just more important than they used to be. Lots of political advocates and activists will use Supreme Courts at the state level to settle issues they hope in their favor. And there's a lot of controversy, social issues, economic issues, environmental issues. So Supreme Courts are doing some pretty heavy lifting, and as a result, they do some controversial things sometimes.
What is the best solution to selecting Supreme Court justices?
Well, if the truth be told, there probably is no silver bullet. Every method can have an element of partisanship to it. Every method can be prone to rather expensive and nasty elections, except for lifetime appointment, which is, of course, is what we have for U.S. Supreme Court justices. I think that in the Wisconsin context, given that we have nonpartisan elections, one thing that some law review authors suggest is that we consider electing a justice for one term only, and that term be pretty long. You know, in the Wisconsin context, it would go from maybe 10 years to 15 or even 20. The idea is that the justice, once elected, would then be free and independent to make his or her decisions without having to worry about a rather uncomfortable election years down the road.
Thank you, Mr. Berry. That's Todd Berry, President of the nonprofit, nonpartisan Wisconsin Taxpayers Alliance. For more information, go to www.wistax.org or call 608-241-9789.